Ever wonder about the lines between personal privacy and law enforcement's ability to investigate? It is a really important balance in our legal system. When police need to search your property, there is a key piece of paper that often comes into play. To answer directly, yes, a search warrant absolutely must be signed by a judge or a neutral magistrate. This signature is not just a formality. It is a fundamental safeguard designed to protect your constitutional rights. Without it, a search is generally unlawful, making any evidence found inadmissible in court. This requirement stems directly from the Fourth Amendment of the United States Constitution. This amendment protects all of us from unreasonable searches and seizures. Before a warrant can be issued, law enforcement officers must present an affidavit under oath to a judicial officer. This affidavit must establish what is called probable cause. Probable cause means there is a reasonable belief that a crime has been committed, and that evidence of that crime will be found in the place or on the person to be searched. The judge or magistrate then acts as a neutral and detached party. Their job is to carefully review the evidence presented by the police to determine if sufficient probable cause exists. They also ensure the warrant is specific. This means the warrant must particularly describe the place to be searched and the persons or things to be seized. It cannot be a general or fishing expedition. This specificity prevents overreach and protects citizens from arbitrary government intrusion. So what does this mean for you? If law enforcement arrives at your home or property with a search warrant, always ask to see it. Look for the judge's signature, the date, and make sure the address matches your location. Also, pay attention to the scope of the search. They can only search 4 items and in areas specified in the warrant. While you should never obstruct law enforcement, you do not have to consent to a search if they do not have a warrant. Politely state that you do not consent to any searches. Now, it is important to know that there are very specific and limited exceptions where police may search without a warrant. One common exception is known as exigent circumstances. This occurs when there is an immediate threat to public safety, a risk of evidence being destroyed, or a suspect escaping. Another is the plain view doctrine. This allows officers to seize evidence without a warrant if it is immediately apparent that an item is contraband or evidence of a crime and they are lawfully in a position to view it. But even in these cases, the foundation of a judge's oversight remains paramount in our legal system. Ultimately, the requirement for a judge to sign a search warrant is a cornerstone of our justice system. It ensures that law enforcement's power to search is not arbitrary. Instead, it is grounded in evidence and reviewed by a neutral party. This process safeguards your fundamental right to privacy. It also holds police accountable to the highest standards of legal procedure. It is a crucial layer of protection for every citizen.